Sir, good afternoon. Can you see and hear us?
Yes, I can. Thank you.
Thank you. Over to Mr. Jacobs, I think.
Yeah. Good afternoon, Mr. Jacobs.
News, sir.
If you haven't finished by 2:45, I'll give you a few-minute warning, as I did with Mr. Henry, all right?
Thank you, sir. Yes. Good afternoon. I represent 157 sub-postmasters, all of whom were affected by this scandal, and a large number of them were involved in the group litigation, which I know that you were closely involved with. Is that right?
That is.
Now, I want to ask you firstly about suspense accounts.
I'm sorry, just before you start, would it be possible to move the microphone? I literally lose your
okay.
slide. I can't see your face.
I have someone saying that they can't hear me and someone saying they can't see me, but I'll carry on. I want to ask you about suspense accounts.
Yes.
And you deal with that at 129 and 130 of your statement, which is your bundle of reference A2. We don't need to turn it up. Mm-hmm. But if we can look at your B141, which is POL 000211762, Mr. Riggs. And if we could have that on the screen, please. And if we could go to the request of second sight, which is on page 3 of that document. And it reads, in light of the disclosure of rolling 3-year suspension. Maybe we need to scroll down a little bit. Are you on page 3? If you could scroll.
I'm sorry, I have it. I have it in my hard copy, if that helps.
Scroll down, please. Here we are. So it's the 30th of July, 2014, 13:25. And it's from Ian Henderson to Belinda Crowe, copying in Ron Warmington and Angela van den Pogard and others. And he says, in light of the disclosure of rolling 3-year suspense account, can we have details of the month-end balances for this account, this was in relation to a particular case, for the last 3 years, together with details of amounts released to P&L, which is profit and loss, isn't it?
That's my understanding of it, yes.
Yes. So, essentially, Second Sight wanted to know whether the monies that sub-postmasters had paid on account of Horizon shortfalls had been held in suspense accounts and then transferred to Post Office profit and loss accounts.
I'm not sure what the particular line of the inquiry was, but it was certainly the transfer of agency monies into a suspense account.
And then if we could go, please, to what Belinda Crowe said on the 1st of August, which is at if we could then go up to Andrew Parsons' suggested response, which is also on page 3 of 5. I think we're there. So he says, Belinda, Angela, as discussed briefly yesterday, I suspect that the information requested by Ian below is highly commercially sensitive. It may well be that the figures in question are quite high, and this may be portrayed as if there are significant sums each month that cannot be reconciled within Post Office Limited's accounts. So significant sums coming from postmasters that can't be reconciled with the general accounts coming into the Post Office accounts. And then the inference from this is that Post Office's processes accounting systems are flawed given the volume of discrepancies. Whether or not this is correct, it is an easy leap to make. Assuming that POL Finance say that this info cannot be disclosed, I've penned a short response to Ian below. And then if we read below, he says, Ian, the information you're seeking is highly commercially sensitive and therefore would only be made available in exceptional circumstances as you described in the suspense account note provided to you. Sums in POL suspense account do not impact on branch accounting but reflect unresolved matters between POL and its clients. I'd be grateful if you could explain why Second Sight need visibility of suspense account figures, given that the Part 2 report and CRRs are only focused on the impact on sub-postmasters. Kind regards, Andy. So what he's doing, effectively, do you agree, is he's deflecting that question. He doesn't want to give that information. He says it's commercially sensitive, and he's saying, why are you asking this?
So there's just one thing I think you said in it, which was this is money coming from postmasters. I actually think the suspense accounts involved monies and exchanges with post office clients, so it wasn't just postmaster money, but it may have been postmaster. So postmasters were certainly involved.
Yes, well,
but,
yes,
but not exclusively. Yeah. And I heard you to sort of read that in.
And
deflect is, I think yes is a word, but I actually say more appropriately clarify.
Well, we're going to come to your response. So we'll move up to page 2, please. And this is Belinda Crowe writing an email saying that they didn't want to provide a ballpark figure. However, Andy Parsons has sketched out a suggested response below. I don't know whether the published accounts give any details or if we make this information otherwise available, but I'd be grateful for advice on how best to respond. I think we should consider this through the lens of an FOI request and how to respond to that. Goes on to say, second site, in the last paragraph, are producing a draft report either today or tomorrow, which is likely to reference this, so we need to have a response within the next couple of days. Now, moving on to your input in this. So if we go to page 1 of 5, this is what you say about the issue. And scrolling down, please. So you say, Belinda, I agree with Andy. I'd like to avoid giving anything, if at all possible. Less is more. But if we do, rather than give them the data they've asked for, we should provide MI. I don't know what that means. Is that minimum information, minimum input?
Management information.
Information, which gives context, including, rather than raw 3-year data, you give the monthly average over the past 3 to 5 years, what that figure is as a proportion of the total month-end transactions and average time to clear in suspense, e.g. something along these lines, and then you give what is a very vague suggested response. The amount held in suspense accounts across the post office network averages X per trading period, or approximately Y of the total value of the transaction processed each trading period. Of the sums held in suspense accounts, approximately Z is cleared within 30 days, and all but F is cleared within 90 days. So that's your response, Mr. Williams.
Yes.
And it's right, isn't it? And our clients who are alive to this issue all say that Post Office did not want this information to get out. They did not want sub-postmasters, they did not want the working group, they did not want MPs to know where the sub-postmasters' money that Post Office was taking from them was going. That's right, isn't it?
I don't know what your clients have been saying to you. I wasn't. I wasn't. Sorry, I was aware there was a question like, you know, if it's gone missing, could it have gone somewhere? And the suspense accounts were a place for that.
Right. Well, that's helpful.
I know that from the post office side of things.
That's helpful. And we can take the document down now, please. What other people have said about this issue? Sir Anthony Hooper gave evidence on the 10th of April. We don't need to turn up the transcript, but for the record, it's page 185 of the transcript. And he's talking about the working group. Mm-hmm. And he said, I couldn't understand where the money had gone. If a sub-postmaster found a loss of £2,000 and paid it out of his own pocket, which they did, or if it was taken out of future income, where had the money gone? And he went on. So I asked towards the end of 2014 for suspense accounts because I thought that I knew there were suspense accounts. I knew that Post Office, after 3 years, took out the profits of the suspense account, and I wanted to know more about it. But then this is what he said. He said, I got absolutely nowhere, and nor did Second Sight. So my question to you is, were you aware, and I know that you were involved in the mediation scheme and the working group, were you aware that the chair of the working group had been repeatedly asking for the suspense account so that he could track where the money had gone, and that Post Office never gave this information?
So two bits. I was involved in the scheme as
Yeah.
and when the scheme required me. I don't recall actively participating in working group discussions, and I think I said in my statement, I recall only attending one in-person meeting, and I did attend some calls. I say that because I was involved in the working group, and I would not describe myself as having been involved in that.
Okay.
Which leads me to the answer to the question, which I did understand. That I have to say feels like news to me, that Sir Anthony Hooper had been asking for it in that context, to that extent. I don't doubt that is the case, but I wasn't aware of it.
So you were a lawyer advising on the mediation scheme, and this request was being repeatedly made, which the chair of the scheme of the working group has told this in inquiry, and your evidence is that this is news to you and you didn't know about it.
To the level you've described it, I don't recall. I was a lawyer working on it as a reminder, but I was aware that suspense accounts was an issue, but I hadn't realised the prominence that Sir Anthony Hooper was placing on it.
If money is being paid by sub-postmasters, theoretically, to balance a shortfall, how would that money, that couldn't ever be represented in the accounts as a profit, could it? That would be fraudulent, wouldn't it?
I'm not an accountant. I can't describe what could or be doing with the accounts. I'm sorry.
Well, I will ask you these questions. You may not be able to answer them. Did you consider that the Post Office had acted fraudulently or improperly in converting monies extracted from sub-postmasters on account of Horizon shortfalls into profit by putting it into the profit and loss account?
I can't comment on that.
All right. And so you don't know how many thousands and thousands of pounds the Post Office profits increased as a consequence of money that they'd been extorting from sub-postmasters?
I can't comment on these areas, sorry.
And can you comment on whether any Post Office directors questioned these accounts because of all these figures turning up that were unexplained?
I have no visibility on that, sorry.
All right. You have referred in your witness statement, I think at paragraph 130, to an end-of-term report, and perhaps we could actually look at that. It's your B55. It's dated, I think, the 30th of July 2014, and the reference number is POL000-40935. And paragraph 55, please.
I'm sorry. Could I have if you gave me it, I'm sorry I missed it. Could I have a...
It's your B55.
I'm sure you did give it. I'm sorry I missed it. B55.
I might have not. Yes. So if we go to page, I think, 15 of 187 of this.
Sorry.
That's for the...
I'm struggling to keep more than one number in my head.
Okay.
Sorry.
Right. Thank you.
I have it, thank you.
Okay, so suspense account data. In June 2014, Second Sight asked the Post Office to explain the operation of its suspense account. The Post Office replied to that request in a written paper in July 2014. Second Sight then made a request for further data on the accounting entries being posted to the suspense account. Given that the purpose of this request was unclear, we would say not unclear, Second Sight agreed to provide further clarity on the nature of the inquiry, which they did in October 2014. Following some residual uncertainty over the focus and purpose of the request, the Post Office sent further written paper to Second Sight explaining the operation of its suspense account. And then 54, while the Post Office acknowledges it originally took longer to respond to the requests, it was able to answer Second Sight's question when a shared understanding of the nature of the inquiry had been reached. 55, Post Office's Chief Financial Officer has now had 2 meetings with Second Sight to discuss these matters and has provided Second Sight with further contextual data. At the most recent meeting, Second Sight agreed that it needed no further information on the suspense account, requesting some further data on another aspect of client accounts to provide additional reassurance. I hope I haven't gone too quickly. It's right, isn't it, that Post Office never provided Second Sight and never provided Sir Anthony Hooper with details of where the monies from sub-postmasters from the suspense account actually ended up?
I don't know what was passed on that. I don't recall. I certainly don't recall having any sight of what was or wasn't presented or considered or given on suspense accounts. I'm sorry.
And do you know where this money would have been held? Where the accounts were? Were they in Chesterfield?
Certain finance functions were in Chesterfield, but I don't know what the split between sites was.
All right. Now, this is a question that I think you might be able to answer. Did it occur to you or anyone else that the money being held in suspense, the amount of and the frequency of payments, would be an indicator of issues within the Horizon system?
No, I don't recall that connection being discussed.
Because you see, if this was a balancing error and the system was out and the sub-postmaster put the money in because the money needed to be put in because there was a real shortfall, then there wouldn't be anything in the suspense account. It would balance, wouldn't it? But if there were huge unexplained sums of money, hundreds of thousands of pounds pouring into these accounts, that would demonstrate, wouldn't it, to you, someone investigating these sub-postmaster complaints or looking into the legal aspects of it, that there was a problem with the system?
I think that's a matter of... I started for 10 on what you've described, which was, with respect, very quick, and I might ask you to slow down.
I will slow down. I am conscious of the time, but I will...
I'm conscious as well, so I'm sorry. That's a question for a forensic... Sitting on what you've just described, I'd say that's a question for a forensic accountant. And then, as a legal advisor, I try and understand what those findings might be. Movements of money, I'm not very good with. I'm sorry.
Yes, but you were quite good with resolving the Horizon issues and dealing with the press. Isn't it quite an obvious point, really, Mr. Williams?
Sorry, which point is obvious?
That you would be able to tell from the accounts whether there was a problem with the system or not.
I think it became one of the sort of part of the sort of response to the challenges about the system and why it was operating well most of the time is it didn't just balance against postmaster branch accounts, but post office sells most of its products for other parties. So those accounts then needed to back off against their systems. And so when they're balancing, there's balancing. So that's probably as far as I can take, and I hope it's not off track. No, as I say, I'm not an accountant.
I've asked you the questions, and we note your answers, Mr. So I'm going to move on to another topic now, which is the group litigation.
Yes. And
can we go to another document, please, which is POL 000-89708.
Sorry, could I have a bundle again?
Oh, yes, and it's your E46.
Thank you.
And if we could go to page 2 of that, these are lists of various committees. I'll wait for you to find the document.
Yes.
So we can see it too, GLO Postmaster Sub-Litigation Committee.
Page 2.
GLO Postmaster Litigation
yes.
Subcommittee. And you say, no need to turn it up for now, but at paragraph 190 of your statement, you say in April 2016, because of the issues in the original claim form in the group litigation, you suggested yourself to Post Office's General Counsel that a steering group be set up for that purpose. So you suggested a steering group for the litigation, and you were on it, and these are the members of it.
No, that's not correct. This is the board subcommittee.
Right.
So I set up a steering group, which were managers within the business. So
that's helpful. So what was the difference then between the steering group and the litigation subcommittee?
I thought I tried to explain that in my statement. In the early phases of the litigation, most instructions, management oversight from within the company was managed through the steering group, which were executives. I think the chair was a colleague called Tom Moran, with the view that they would be able to help the business respond to the allegations, give instructions to external lawyers and the like. Mm-hmm. And then that committee could report to the group executive, which were the senior management, most senior management, I should say, so the C-suite and related colleagues. And then reporting to the board would be however that fitted within the group exec or GE and the board. So the second bit, at a stage, and I think I put the date somewhere in my statement, at some stage, I think it may have been 2018, which would be consistent with this document, which I have to say I hadn't seen before. The board decided they wanted to spend more time or give more focus. This is what I understand. The board wanted greater focus on the litigation and set up a subcommittee so that it could receive more direct, I guess, feedback on the direction of travel and status of the litigation. Typically done the day before a full board meeting so that the subcommittee's knowledge could be taken forward into the wider meeting without taking up the full board meeting, which I understand it was taking up more time for the board than they had available. Okay. Bearing in mind there are other considerations.
Well, that's helpful. Well, if we scroll down, we can see, I think, that you were on the litigation subcommittee. You're there at number 9 in 2018.
Yeah, I wouldn't have said I was a formal member. I don't know. I don't know this document. I don't know who prepared it or where the names came from in it. But I certainly did attend some meetings of it, and then I think certainly later, at least after, I think the common issues judgment came down. I started attending the meetings regularly.
Well, we can see the names. If we scroll down to 2019. You can see at number 9, scrolling down a bit more, please, that you are there as well, yes. Rodric Williams. So, and you were on the steering group as well, weren't you?
The steering group, yes.
Okay. So, I'm going to read you from paragraph 108 of Alan Bates' witness statement. We don't need to turn it up, but this is the point that we're going to be talking about. He said, and he confirmed this in his evidence on the 9th of April, it's public knowledge that Post Office knew we had funding for the litigation. They will have known that we had access to a finite pot of money, and the harder they fought, the more that funding would be depleted. In my opinion, this was a very cynical approach. The steering committee and I were advised by leading counsel and Freeths that it was in the best interest of the claim group as a whole to settle the proceedings at the time. Post Office had effectively outspent the 555 claimants, and the risks of continuing with any litigation without adequate funding, and possibly without ATE insurance, was a risk. Was not a risk which any of the claimants should have taken, given that they'd suffered so much already at the hands of Poll. Post Office Limited. And in his oral evidence, Mr. Bates said it was very, very obvious that Post Office had a strategy of trying to force the claimants, who were winning the litigation, to settle and abandon their case, abandon their claims, because they had run out of money. Before I ask you a question about that, I want to turn to another document, which is POL 00006380, and that's your B234.
My B234.
234. And these are steering group meeting notes of the 11th of September 2017. Thank you. And if we go down to page 2 of 15, you'll see overall Post Office strategy. I hope
sorry, again, you're going very, very quickly.
I am. I'm sorry.
And I have to. I just like to say, in case it helps, and I'm sorry if I'm interrupting. I didn't see Alan Bates's evidence, and I haven't read his statement. So I'm.
Yeah. No doubt, you'll take it from me that.
I'm sure it was. If there are parts of it that I'll need to be taken back to.
Yeah.
I beg your pardon.
Let's look at paragraph 4.3, shall we?
Sorry, I'm sorry. You have to take me back. Which tab? Which page?
It's your B234.
Thank you. And the page?
And page 2, paragraph 4.3. It's on the screen. I think I'd rather look at the screen, Mr. Williams.
Yes, I have that. Thank you.
So we believe the better solution is to try to force the claimants into a collective position where they will either abandon the claims or seek a reasonable settlement. It should be remembered that the claims are financially supported by Freeths, whose fees are at least partially conditional on winning, a third-party funder and insurers. Without this support, these proceedings would not have been possible. All three entities will likely have the power to pull their support if the merits of the case drop below a certain level. Our target audience is therefore Freeths, the funder, and the insurers, who will adopt a cold, logical assessment of whether they will get a payout rather than the claimants who may wish to fight on principle, regardless of merit. Now, I know this is couched in terms of merits, but it's right to say, isn't it, that Post Office were targeting the pockets of the funder, the insurers, and the lawyers.
No, I don't think that's right. I do not recall that being... Sorry, no, I don't.
Okay. Well, you were on this
Yes.
steering committee, weren't you?
Yes.
And this is part of the Post Office overall strategy, isn't it?
Well, it's a recommendation that was drafted. So I think, again, in my statement, I said we'd asked Bond Dickinson to draft discussion papers, working papers, I forget the full description of them, for the steering group to read and consider, so that decisions on both overall strategy but also certain specific items could be deliberately made. Again, in my statement, funding was part of that, but it was never the main thing. Started for 10, we didn't know what funding was available.
Well, I'll move on. Let's have a look at another document, shall we? POL 00006379. You deal with this in your witness statements as well, and it's your B235.
Thank you.
This is a Bond Dickinson document which
yes.
also deals with... Oh, sorry, it's some more steering group meetings.
I think this was an appendix to the previous document, I think.
If we could go down to section 5, please, so scroll down. So these are all the options that were considered. And if we stop there, please. Now, this wasn't a recommended option, but my clients say, and Mr. Bates has said, this is what ultimately prevailed in terms of the strategy. So I'll read out what the attrition strategy was. Stretch out the litigation process so as to increase costs in the hope that the claimants, and more particularly their litigation funder, decide that it is too costly to pursue the litigation and give up. Now, the question I have for you very simply is, that is exactly what happened, isn't it, Mr. Williams? Exactly what happened.
No, it's not.
And why do you say that the postmasters and Mr. Bates, when they say that is exactly what happened, are wrong?
Because, one, funding was never anything we had visibility of. That we had the security for costs application was made, which gave some insight into it, but not the details. But mostly, the case management directions for the conduct of the litigation provided for clearly defined steps for at least the first 2 trials in a very short period of time, and cost budgeting, which were agreed. So the parties' costs were known and understood as we went through. That's my understanding of it, and also personally, that's how I recall us conducting the litigation.
All of my 157 clients, and no doubt Mr. Bates, would say collectively that is not true, Mr. Williams.
I'm sorry, but I've given my evidence.
Very well. We'll move on to another document, which is a letter. Again, you deal with it in your witness statement, but we should see it. It's your B39. It's a letter that Mr. Parsons of Bond Dickinson wrote to you on the 16th of October 2017. And that is POL 00000. That's 5 zeros and then 444.
I'm sorry, the number again.
It's your B239.
239. Sorry. I have it 238, the email, and 239. I think
we've gone to the wrong one. But actually, it's not a bad idea that we do show this, because this is a witness statement. If we scroll down, please, from Andrew Parsons, and it is, if I can read my own writing, it's 227 pages long, and it's
yes.
in relation to a CMC issue, isn't it?
Yeah, the first, I think this was created before the first case management conference.
Okay, so fortuitously, we'll now know what the next document is about. If we can go to POL 000-41509, which is your B238.
Might you? Yeah, thank you. I have that, thank you.
Thank you. So we'll just wait for the for everything to catch up. Here we are. So it's a letter from Andrew Parsons to you, and he says, another funny letter from Freeths attached. My witness statement has really annoyed them, no doubt because it was 237 pages long. This is good. The more time they waste on side correspondence, the less time they are spending on important matters! Exclamation mark A. So it was a source of amusement, wasn't it, that you had a strategy to run down the claimant's limited costs and waste time as a way of putting pressure upon them.
I think the question is in two parts. It's
Yes,
source of amusement.
Please answer both.
The second part of the strategy, I think I said, I don't recall it ever being a strategy to run the amount of money. As I say, we had cost budgeting for that, and we didn't know what the sums were. So the second bit, a source of amusement, no.
Why was it a funny letter then?
Well, Andy wrote it, so.
No, why was the letter from Freeths funny?
Well, that's how Andy Parsons has characterised it.
He thought it was amusing, but you didn't.
Well, and my thing, I've seen the letter. Funny is also peculiar.
Well, that's fine. Let's not dwell on that, on the semantic point. I think what the bigger point is that it's accepted, I think, by the steering committee that the average value of each claimant's claim in the group litigation was £200,000. Would you agree with that?
I think that was the number we got from collating schedule of information data. So that was a number that was put on it at that time with that information, yes.
And I think you will also accept, it's been quite widely reported, that on average, although some got significantly less, on average every claimant got about £20,000 when the case settled because of the costs issues.
When we settled the case, it was a lump sum, and the division was for the claimants to do and the advisors, and that was not something I recall Post Office being privy to, and in fact we were expressly sort of excluded from it.
But you take no issue then, do you, that as a result of the way matters unfolded, claims that were worth £200,000 on average yielded £20,000 on average? And
sorry, the question on that, I'm sorry?
You wouldn't dispute, would you, that as a result of how matters unfolded in the litigation, the claimant's claims that were worth on average £200,000 each reduced to, on average, £20,000 each?
Well, I don't know if it was as a result of the way the litigation went or the arrangements that they had with funders and legal teams. But if it helps, I can understand a sense of...
And I have to suggest to you that as a member of the steering committee, as someone that was intimately involved with litigation, you knew exactly what you were doing. This was your strategy of attrition that the Post Office adopted throughout. Mr. Bates has given very compelling evidence, as have the majority of our clients on this point. Can you now, with the benefit of hindsight, accept that is what you did?
No, I can. And again, I'll say this. On the attrition point in particular, we had case management orders for the first two trials. And in fact, we also had further case management orders for a third trial that stood up two enormous trials in an extremely short period of time. I think if you take the two dates from, I think, October 17, when the first case management conference in front of the managing judge came up with the first proper directions were given, through to the conclusion of the Horizon trial, which I accept was greatly disrupted by the recusal matters. But even allowing for that, those two trials were concluded, I think, with roughly 18 months plus or minus. And I could say, like, in terms of attrition, which I take to mean slowing down, drawing out, it's quite the opposite. That was pretty hard going.
Well, attrition means attack the funders, attack the money. We've seen in the emails what attrition means. And that's what the
Well, I'm saying that I don't believe we did that strategy. I believe we tried the two cases because until those were resolved, any resolution would not be possible. That's my assessment of it.
You gave evidence yesterday to say that you are now working on the historical matters remediation unit in the post office.
Well, I'm not actually working on much at all in
You've
particular
taken some
other than
time
the
off
inquiry.
for this, but generally speaking, that's what you do when you're not involved in this inquiry.
That's what. So what I think my statement I've said this. What I've done is I was moved from the business as usual legal team into the remediation unit, where focus was put on remediation issues.
Our client simply cannot understand why a member of Post Office's steering committee that helped drive the group litigation with all the tactics that Post Office employed is now working on the historical matters remediation committee. What our clients say is that you are one of the historical matters. You shouldn't be remediating against your own actions, should you?
I think that's fair. My role, very much as I've seen it in the remediation unit, was by this stage, but by the time, certainly but probably by the time of the Common Issues judgment, and certainly by the time of the settlement, effectively, from my experience and what I was witnessing, the conduct of the group litigation was largely being overseen by the board or the subcommittee, certainly the board in either guise, with direct input from the external lawyers. And most of my job with that was ensuring that the external lawyers' advice passed to the board without. But I was
you
working on it.
You attended the
yes.
trial, didn't you? You were heavily involved.
Yes.
I'm going to move on now because of the passage of time. I want to ask you about Gareth Jenkins. You have been taken to the Simon Clarke advice at length, where the Post Office were advised that Mr. Jenkins was fatally undermined as a witness.
Yes.
You know that Brian Altman, Casey, in his general review, said that Mr. Jenkins was tainted and his position was untenable. It was right that he was never instructed as to the duties of an expert, was he?
I don't know that, but we have been through a note where that's recorded as having taken place.
So
Whether it was or not, I'm not sure.
So the revelations that Mr. Henry put to you as apocalyptic before lunch were such that quite clearly Mr. Jenkins couldn't give evidence in the group litigation, could he?
And I think we formed that view, that's correct.
Can we go, please? And this isn't a document that you have in front of me. You will have to look on the screen, but it's the Horizon Issues Judgment, so I think you might be familiar with it.
Well, parts of it.
Okay, so if we go to UKGI 000181137, and this is my last point, sir, so I'll endeavour to be quick and not waste the time. So if we could move to that judgment on the screen, please. And just waiting for it to come up. Do we need the reference again?
No, I think the reference is fine. It's just such a long document.
Yes, it's a very long document. yes. So if we get down to page 29 of 313, which is paragraph 77. So we can see at paragraph 77 that there was an issue in relation to Mr. Jenkins. So if we go down to the 6th or 7th line, you can see expert evidence was called by the Post Office at her trial from Mr. Gareth Jenkins from Fujitsu. Mr. Jenkins was not called as a witness by the Post Office in the Horizon trial before me, but a large amount of the evidence from the Fujitsu witness, that's Mr. Jenkins, was attributed to information directly given to them by Mr. Jenkins. This was a controversial matter between the parties at the Horizon trial. The Post Office did not proffer an explanation for Mr. Jenkins' non-appearance as a witness. They were not obliged to do so. However, in their closing submissions, and after all the evidence had been called by both parties, they did so. The explanation was provided by way of submissions and not evidence. And then if we go down to page 152 of 313, paragraph 511 of the judgment, please. And we can see that there was an issue, looking at 511, that the claimants asked why there was no statement from Mr. Jenkins, whether he was available to give evidence, and also whether he was involved as one of the team of the shadow experts. And we heard about shadow experts in questions put to you before lunch. And then at 512, there the matter might have rested. However, in Post Office's written closing submissions, an explanation of sorts was for the first time provided. This was in the context of two matters. Firstly, by way of explanation, Mr. Goddseth's evidence, and he's the man who did give evidence, and potentially to downplay its impact. And secondly, in relation to the claimant's complaints about the second-hand nature of some of the Post Office factual evidence, because in large part this had emanated from Mr. Jenkins. And the explanation was, at 1441, taking into account that Mr. McLaughlin's evidence specifically addressed things said or done by Mr. Jenkins in relation to the Misra trial, Post Office was concerned that the Horizon trial could become an investigation of his role in this and other criminal cases. 144.2, however, Post Office was conscious that if it only adduced first-hand evidence in the trial, it would end up having to call more witnesses, and they go on to say that it would have been 34 extra people having to give evidence. And 1443, furthermore, so far as Post Office was aware, the relevant parts of Goddseth 2 were unlikely to be controversial. For example, the Misra trial was a matter of public record. The 4 bugs were covered by contemporaneous documentation, and Post Office had no reason to doubt Fujitsu's account of the documents it held. Now, if we could move on to paragraph 514, please. And the judge says the following important in my judgment of primary importance is the principles for each party to decide who to call. And Mr. Jenkins is an important and central person so far as the operation, efficacy and robustness of Horizon is concerned. And it goes on to say that's reinforced by Post Office's own closing submissions that there were 2 possible candidates for the witness. It also stated that taking into account Mr. Jenkins' involvement in the Misra case, the decision was used taken to use Mr. Goddseth. And then at point 4, going down, please, the Post Office chose not to proffer a reason for Mr. Jenkins' absence in closing submissions, chose to proffer. They were not obliged to explain. However, the reason given in paragraph 1441 quoted above is not a valid reason for his absence. The claimants would have been entitled in cross-examination to put to Mr. Jenkins any previous inconsistent statements he'd made on the same subject, but obviously only if there were any. These could potentially have included previous statements he made in earlier proceedings, but in order to be allowed to do that, such statements would have to be inconsistent with his evidence in the Horizon Issues trial. Putting previously inconsistent statement on a particular fact is permitted as part of cross-examination. It goes on to say the Horizon trial wasn't about Mr. Jenkins, it was about Horizon issues, and this type of cross-examination would only have arisen if any statements in the trial were not consistent. And then, nearly at the end now, point 7, the fact that the Post Office chose to advance certain evidence in the Horizon trial that emanated from Mr. Jenkins by means of another witness saying Mr. Jenkins told me that means the claimants were deprived of the opportunity to properly test the evidence by asking Mr. Jenkins about that. It also emerged in cross-examination, although not in his written report, that Dr. Worden had also obtained certain information directly from Mr. Jenkins. By dealing with this material in this way and having deprived the claimants of the opportunity to cross-examine Mr. Jenkins, the weight to be given to the evidence emanating from Mr. Jenkins is less than it would be otherwise. Now, I have some questions to ask you as someone who was involved in the steering committee. Who gave instructions to counsel to the litigation firm instructed to draft closing submissions in this way?
Council held the pen on their closing submissions. The closing submissions, I think, are very, very lengthy for this trial.
And who was responsible within Post Office for approving the written submissions to which Mr. Justice Fraser referred? Were you involved in that?
I can't even remember if I saw a draft of them at this stage. The time pressure to put them in. I don't recall the sequencing of what they'd be doing. My personal recollection of that is that these were council's closing submissions.
Well, I'll ask you another question. You were involved in these submissions, weren't you? You were involved in this process, weren't you?
Not much with this at all. I wouldn't like to say none, because it's quite possible I did, but not much, no.
Right. I have 3 more questions for you. Do you accept that the giving of an excuse about the failure to call Jenkins in the High Court action was a flagrant and deliberate act to provide instructions to gloss over the non-calling of Jenkins in circumstances where some Post Office staff and directors knew that his credibility was in doubt?
I'm sorry, there's so much in there.
Yeah.
It doesn't lend itself to a yes
Do you
or no.
accept that giving an excuse in the High Court that was a false excuse was deplorable, because essentially you knew, and those within Post Office knew, the reason he hadn't been called wasn't because of what you told the court. It was because he was tainted and he wasn't a safe witness to call because of the Clark advice.
Well, the reason was given was sorted out with the legal team on instructions, with the benefit of the discussions around Jenkins. So, as far as I'm concerned, the excuse given was done with an understanding of the position.
You've said,
and also, with the benefit of counsel's input on it.
my final point to you, you've used the word excuse. This wasn't an excuse. This was a cover-up, and this was misleading the court, wasn't it? Ultimately, you must accept that.
I don't think anybody involved in certainly the legal team, I can't speak for anybody else, but I don't believe I would want to mislead a court on anything, and I don't believe anybody in the legal team would have wanted to have done that either. And so the excuse, however we've described, so the answer to the question is no, because
well, let me
we wouldn't
put
want
it
to do that.
In another way. Mr. Henry asked you about your professional duties and obligations. How could you, acting professionally, knowing what you know, having read the Simon Clark advice, having read Brian Altman Casey's general review, how could you sanction putting forward the reasons why Mr. Jenkins wasn't called that were put forward? That was misleading the court, wasn't it? It's quite clear.
Sorry. No, I don't accept that. But also, I'll go back to the plenty of references you read through very quickly. The choice about whether to call Jenkins or not is that is one for the parties to do. And as I say, we Post Office did.
Hang on, Mr. Williams. We know why you didn't call Mr. Jenkins, or at least there is a document which explains that before the litigation, which was that you thought his credibility was shot.
Yeah.
And that's why you didn't call him, isn't it?
It is.
Now, why you chose to use him to provide information is a different issue. But the reason why he was not called is what transpired at the conference that we went through this morning.
Sir, yes, it is, sir. And where I think I'm going on that is that was all connected to his engagement in criminal proceedings, as opposed to the ones we were here before.
Sure. But the reason he was not called was because the view was taken that his credibility had been irretrievably lost.
Yeah, and tainted. Correct, sir. Yes.
Thank you. Right. Any more, Mr. Jenkins?
I haven't any others. I haven't any more to add, so that's...
Thank you.
Thank you.
Then thank you for keeping very substantially within the time, and we'll move to Mr. Maloney.
Thank you, sir. I'll try to do the same. Mr. Williams.
Sorry, thank you. I beg your pardon.
I've 3 things to ask you about. Firstly, the shredding advice from Simon Clark. Secondly, Crown officers, just a small topic that is. And then thirdly and finally, remote access knowledge within Post Office. So the first one is the shredding advice. from Mr. Clark, and I've been permitted in advance of today to ask you questions about this. Mr. Beer has already asked you some questions, and I'll try not to repeat them.
Thank you.
Okay. In response to the shredding advice that Mr. Clark sent, and we know that he wrote it around the 2nd of August, and Susan Crichton replied to it on the 16th of August, so some 2 weeks later. You drafted the letter for Susan Crichton to send to Andrew Cash, didn't you?
Yes.
Yeah, and Andrew Cash, just to remind everybody, was the, I think, head of advocacy at Cartwright King, in fact, was his formal term. But he was the main lawyer that you would have contact with for this at Cartwright King.
He was the client partner,
Yeah,
as opposed
exactly.
to...
So
yes.
he was the partner. Now, the letter that you sent, or you drafted rather, for Susan Crichton to send to Andrew Cash, could we please look at it? It's POL 20193-605. That's 20193-605, and it's B67 in your bundles, Mr. Williams.
Sorry, conscious that I'll deal with it on the screen.
Oh,
so-
okay,
so,
okay.
no,
Yeah, no,
thank you.
absolutely.
I'm conscious of time.
Yeah.
And I've seen this today, so thank you.
Yeah, sure. Now, and having looked at it today, we know what the first couple of paragraphs say, and a key purpose of the horizon calls is identified in that second paragraph. But if we go to the third and fourth paragraphs, just to see what you say about that, the third paragraph reads that I'm therefore deeply concerned at the suggestion in Simon's notes that there may have been an attempt to destroy documentary material generated in connection with the Horizon calls, specifically any minutes of the calls. I note that Simon's advice does not suggest that material connected to the operation of Horizon itself may have been compromised. And then in the fourth paragraph, Post Office Limited is committed to conducting its business in an open, transparent and lawful manner. Any suggestion to the contrary would not reflect Post Office Limited policy and would not be authorised or endorsed by Post Office Limited. Accordingly, the purported statements referred to in Simon's note do not reflect or represent Post Office Limited's position. Yeah.
Yes.
Now, the allegation made by Mr. Clark was extremely serious, wasn't it?
I think we've agreed. Yes.
And just to, as it were, deal with one line of questioning that you faced this morning, did you carry out any sort of investigation before drafting this letter? And just as examples of that, did you contact Mr. Clark to ask where his information came from?
I don't believe... I may have spoken to him. I don't recall. I may have spoken to Martin Smith. I don't recall either way.
Okay.
I certainly don't recall doing it.
Yeah. If you had, would you have included in the letter a summary of what either Mr. Clark or Mr. Smith said to you in response to the question as to where the information came from, do you think?
I may have done. As I say, I'm not sure whether I did or didn't, so I don't know whether that contact would or would not have fed into the letter.
But if there was any response from them, it would be, you would include, for example, I know that Mr. Clark absolutely stands by what was said to him, and so you'd report to Susan Crichton what you'd said, and that would appear in the letter, wouldn't it?
Yes, I mean, I think the starter for 10 is, I think if Simon's note recorded it, it's probably what Simon heard.
Yeah, but there's no mention in here, for example, of having spoken to Mr. Clark about it, nor indeed Mr. Smith.
No, I don't think there's a reference to that, no.
Did you speak to Mr. Scott at all?
I don't recall doing that, no.
And what about Mr. Singh? Because he was in the same open plan office as you. Did you speak to Mr. Singh about what it was that Simon Clark was alleging had been done in relation to these minutes?
I don't recall that either way. So I don't recall it, no, I'm sorry. Sorry, I was sorry for the hesitation. I was reading while I went, which I shouldn't have done. I'm sorry.
Yeah. If you hadn't spoken to anybody, it's perhaps premature to be deeply concerned at the suggestion. If by speaking to people, you may have been able to find out that there was some substance to the suggestion.
Sorry, can I have the question again? I think yes, sounds right. I just want to make sure.
I'll try and put it in easier, more simple terms. If you hadn't spoken to anybody, and you can't remember that you did,
No, that's good.
is it perhaps a bit premature to say I'm deeply concerned at this suggestion?
No, I think the suggestion stands on its own as something to be deeply concerned about.
Right.
And I'm sorry for the pause when I was reading ahead, and I'm trying to think what was going on there because you were asking me what did I put in, what did I not. I think this looks like it's drafted as a corporate position. This is what's supposed to have happened. I trust this, and what the position. So what should have been happening with the material and being recorded at these meetings.
Yeah.
And what the position is, which was that no matter what may or may not have been said at an individual, the company's position, which is something that I would think the General Counsel is responsible for, did not support it.
Yeah. And if you'd actually spoken to somebody, you'd have been able to say what the reality was instead of simply the corporate position, wouldn't you?
Quite possibly, but as I don't recall who was spoken to and what context around this. I'm sorry, I just don't.
No. Now, I'm going to come to the shredding advice in a moment, but before I do, can I briefly go to the conference at Mr. Altman's chambers in October 2013?
Yes.
And that is poll 406485. And it's B80 for you, Mr. Williams.
Thank you very much.
I have it, thank you.
Yeah. And could we go to the final paragraph on this page, please?
Yes.
I just want to touch on these things and your recollection of this, Mr. Williams, because it bears on the evidence of others. RW, that's you, isn't it? Yeah.
I don't think so yet.
Yeah. Then confirm that the weekly hub meetings were starting to bed in, picking up any issues across the business which may relate to Horizon. SC, and that's Simon Clark, isn't it, rather than Susan Crichton?
I'm not sure.
Okay, well, we can maybe clarify that in due course. I don't want to take up time on this.
SC had said there's some cultural issues.
Is that
That's the
ESC?
one. So-
I read that as being Susan Crichton, but I'm
Okay. Well, if you go to the top of the page, actually, please, just for a moment. I'm sorry. The document
They're
that
both
Chestico
SC.
we see there as Simon Clark SC. Oh, I see, but they're both SC.
They're
Susan
both SC.
Crichton and Simon Clark. So down to the bottom of the page again then, please. Well, it must be Simon Clark because it says SC said that there had been some cultural issues at the start which had now been overcome, but he thought that it was necessary to put duties on individuals.
okay. I
So
think, thank you.
we
that's
know now it's Simon Clark.
I didn't know how Simon. It didn't feel like Simon would be talking about cultural issues, which felt like an internal post office thing. So my apologies.
Quite. That's and that's perhaps an important point, Mr. Williams, because with Simon Clark referring to cultural issues at that juncture, could he perhaps be referring to attitudes to disclosure there?
It's possible. I don't know what Simon would have been referring to. I think I don't know what Susan would be referring to, but when I looked at this, I thought I might be able to have a better go with Simon. I'm less sure. I'm sorry.
But you've no recollection is probably the most important point.
I think it is. Thank you. Sorry, I don't recall.
And then it carries on. Consequently, Cartwright King are in the process of writing a protocol to explain the purpose of the weekly hub meetings, the roles and responsibilities of individuals. Post Office Limited were picking up issues which we compiled, if we go to the next page please, in the matrix, and it was observed that there had to be continuity of individual attendance at this meeting and that everyone must be on message. So that reference to observe that there had to be continuity of individual attendance at this meeting, have you any recollection of that perhaps relating to certain individuals attending sometimes, but essentially sending other persons to represent them at others?
No, I actually think, particularly in terms of the start point, that there was, I seem to recall a bit of a, there had to be a bit of a drumming up to ensure that attendance at the meetings from the right people, and that included from other parts of the business that were not legal, security, connected with prosecutions.
Okay. And everyone must be on message. Was that essentially taking the same approach to the collation of material?
That's how I read that.
Right.
But
Thank you.
that's how I read that.
Yeah. Now, I'm just briefly touched on that. Could I please go to the shredding advice, which is POL 406799. And to paragraph 5, please. And this paragraph 5 is where Mr. Clark relates what it is that's been conveyed to him. So we thank you very much. So we see at paragraph 5, at some point following the conclusion of the third conference call, which I understand to have taken place on the morning of Wednesday, 31st of July, it became unclear as to whether and to what extent material is either being retained, centrally or disseminated. The following information is being relayed to me. And then firstly, the minutes of a previous conference call had been typed and emailed to a number of persons. An instruction was then given that those emails and minutes should be, and have been, destroyed. The word shredded was conveyed to me. Now, in your draft letter for Susan Crichton, you suggested that the contents of this advice caused deep concern. You said, I'm therefore deeply concerned at the suggestion in Simon's note. Yes?
Yes, that's what I understood.
Did that first point cause you deep concern?
Well, there are two bits. The giving of the instruction,
Yep.
if it had been given and the word shredded,
Yeah.
that, as I've said, was the concern.
Okay, that caused you deep concern.
Well, for me, any
Yeah.
suggestion of shredding is deeply problematic, deeply concerning, because you don't. But if it's the first bit, the minutes had been typed and emailed, that piece would have been less concerned because it's an email is very difficult to shred.
Well, this says that handwritten minutes were not to be typed and should be forwarded to Paul, Head of Security. Did that cause you any concern?
Well, it would have done. Yes. Well, no, I mean, not necessarily. The keeping of handwritten minutes, as opposed to typed ones,
But not to be
and
typed.
it's a run. Well, it would have been odd in Post Office to have done that. That feels like you're trying to get around something.
Quite. Then at 3, Roman 3, advice had been given to Post Office Limited, which our reporters relayed to me verbatim. If it's not minuted, it's not in the public domain and therefore not disclosable. Is that something that caused you any concern?
It caused me, I think, confusion when I read it, and still does, because whether something's in the form of a minute or not doesn't determine whether it's in the public domain, and neither does being in the public domain determine whether something is disclosable. It's disclosable if it's disclosable, whether it's held internally or on a website.
But what about the final bit? If it's produced, it's available for disclosure. If not minuted, then technically it's not.
Again, if I look at the front bit of it, if it's produced, it is available for disclosure. That feels correct. If not minuted, then technically it's not. I don't think that's right. So I take this as a sort of confused. I found this confusing, this message. So.
Right. And then some at Paul do not wish to minute the weekly conference calls.
Yes, I can see that.
Yeah. Now, may I take you, please, to a different document, which is Paul 20107-696. Now, this is a document that was sent to you, I think, yesterday, Mr. Williams. It's an email from Emily Springford. Could we go to, I think it's the second page of this document, please? Yeah. And if we keep going on, please, actually. Yeah. So this is quite a long email, but and do you have it in hard copy, and would you like to see all of it, or are you okay on the
No,
screen?
I'm fine, and thank you for checking. I'm sorry.
Now, this is an email from the 20th of October of 2011, and it's from Emily Springford. Now, Emily Springford, she was a senior lawyer at Royal Mail from 2009 to 2012. And if we go right to the end of this email, I'm sorry to, for the document examiner, to the end of this email, we can see what her role was. We see there, Emily Springford, Principal Lawyer, Dispute Resolution. Mm-hmm. Yeah. And could we go back to where we were, please? Thank you. Did you overlap with Emily Springford at all, Mr. Williams?
I only saw this literally, I think, 5 minutes before we started this morning, and my very quick read is I think the whole chain is before I joined Post Office.
Yeah, yeah. Well, it is, because it's October 2011. But did you overlap with Emily Springford at all, or because she left in 2012?
I don't recall ever meeting her, no.
Okay. Anyway, this, as we can see from the first paragraph, says, as you're aware, Post Office has received 4 letters of claim from former sub-postmasters, making a number of allegations about the training they received, the support available to them, and the Horizon system itself. So this comes in the wake of letters before claim from 4 former postmasters, including the late Julian Wilson, who didn't live to see his conviction quashed. And I don't use that as a stick to beat you, Mr. Williams. It's simply, I think it ought to be remarked upon something of that nature. But it goes to a number of very senior people at Post Office, as we can see. So it goes to Angela van den Bogert, Leslie Sewell, who was the head of IT. The names are very familiar to people regularly attending these proceedings: Mike Granville, Dave Pardo, Rebecca Mann, Hugh Flemington, Dave Simpson, Mike Young, Kevin Gilliland, Susan Crichton, Chris Day, Sue Huggins, and John Scott. So in effect, it's to the top brass on a day-to-day basis, isn't it?
I certainly recognise quite a few of those names. Yeah. I don't know the place in the company at the time.
Yeah. Now, the final paragraph on that page says, please ensure that this communication reaches everyone in your department who has access to or who is in a position to create documents relating to the issues arising in the claims as set out more fully below. I've started a list of teams which we believe may hold relevant documents. The list is attached. I should be grateful if you would let me know of any other teams which might hold documents relevant to the claims. If we could please just move down the page beyond document preservation to document creation. Now, this reads, if you just give me a moment, please. This reads, it's very important that we control the creation of documents which relate to any of the above issues and which might be potentially damaging to Paul's defence to the claims, as these may have to be disclosed if these claims proceed to litigation. Your staff should therefore think very carefully before committing to writing anything relating to the above issues which is critical of our own processes or systems, including emails, reports, or briefing notes. We appreciate that this will not always be practicable, however. where it is necessary to create a document containing critical comment on these issues, it will in certain circumstances be possible to claim privilege over the document so that Paul will not have to disclose it in any proceedings. As litigation is now a distinct possibility, the document will be privileged if its dominant purpose is to give or receive legal advice about the litigation or to gather evidence for use in the litigation. This also applies to communications with third parties, i.e. with other organisations, provided they are confidential and their dominant purpose is as set out above. All the following steps should be taken in order to maximise the chances of privilege attaching to the document. If the dominant purpose of the communication is not to obtain legal advice, try to structure the document in such a way that its dominant purpose can be said to be evidence gathering for use in the litigation. Make every such communication legally privileged and confidential. If you're sending the document to someone, stating the covering email or memo or letter that you're not waiving privilege by doing so. Request that the recipient of a communication confirm that the document will be kept confidential and that he or she will not forward it to anyone else. Think very carefully before replying to all on an email. Do all the recipients need to see the communication? Where possible and appropriate, copy a member of legal services into the communication and make clear that, and on the next page please, you are doing so to enable them to advise on the content. Please note that copying a member of legal services into the communication alone will not necessarily suffice. If in doubt, call legal services before committing anything to writing which relates to these issues and contains critical wording. Now, just to be clear, could we go up from this email to see the next email from Emily Springford, who obviously is very keen to ensure that this message is conveyed to all places where it needs to be received. And so it's the next, yes, here we go. So this is to Alison Bolsover, John Breeden, Sue Richardson, Graham Paget, Sarah Rimmer and Dave Holbert. Please see the email below. This message should have reached you via your team leaders, but the interests of certainty, I've included it here. Now, the effect of this, Mr. Williams, is essentially, if you want to impart something critical about Horizon, be very careful before you put it in writing.
Yeah, well, about the complaint, I think is but yes, it's care and communications. Yes.
It is. It's yes. Don't put anything in writing that might cause us problems in the litigation.
I'm sorry, I've literally read it for the first time this morning, so I don't feel I can comment on that. But it's certainly, it looks to follow similar communications I've seen that goes out as what called litigation hold letter when litigation is anticipated. I'm just saying that's how I read it.
Can we just go back to, please?
I'm sorry, I'm sorry. That's,
I'm just going to take
being asked things about something I don't...
I just want to take you to this because I'm going to take you back to the Clark advice, the Shredding advice in a second, and to document creation, please. Look, now, as a lawyer now, Mr. Williams...
I'm sorry, I was skim reading it as we read through.
Yeah, well, let's just go through it a little bit carefully then. It's very important that we control the creation of documents which relate to any of the above issues and which might be potentially damaging to Paul's defence to the claims. Yep. So that's the important issue. Might be damaging to Paul's defence.
I see that.
As these may have to be disclosed if these claims proceed to litigation. Thinking about disclosure.
Understood.
Yep.
Yes.
Your staff should therefore think very carefully before committing to writing anything relating to the above issues which is critical of our own processes or systems.
I'm sorry, thank you for taking me back to that. So yes, I can see that, yes.
Entirely. And then, just to add a gloss to that, with the use of privilege, where it's necessary to create a document containing critical comment on these issues, it will in certain circumstances be possible to claim privilege over the document so that Paul will not have to disclose it in any proceedings. As litigation is now a distinct possibility, the document will be privileged if its dominant purpose is to give or receive legal advice about the litigation or to gather evidence for use in the litigation. But then it says, if the dominant purpose of the communication is not to obtain legal advice, try to structure the document in such a way that its dominant purpose can be said to be evidence gathering for use in the litigation. Now, the whole thrust of this is that if people commit critical opinions on Horizon or critical facts on Horizon to writing, then this might cause us trouble for us in the litigation. In fact, we might even lose the litigation, is the ultimate effect of it. And ironically, this is in writing, in black and white. Can I go back to the shredding advice now, please? Which for the document handler is 406799. And to paragraph 5 again, please. Now, if we look at Roman 3, advice had been given to Paul, which I report has relayed to me verbatim. If we look at the second aspect of that, if it's produced, it's available for disclosure. If not minuted, then technically it's not. Advice had been given to Paul, which I report has relayed to me verbatim. If it's produced, it's available for disclosure. If not minuted, then technically it's not. Isn't that precisely in accordance with the diktat of Miss Springford back in 2011?
I'm sorry, I'm not necessarily making that, but I'm also not. I don't feel I can give evidence on those two collations without. I'd want to take time, I don't think I'd add much to it. I'm sorry, unless I can. I think you're asking me to agree a submission almost.
Do you not? No, I'm just asking you. Do you not see the similarity between that approach and the approach what is said by Miss Springford in her email in October 2011? And is that not advice which has been given by a lawyer in post office?
At best, I've seen the advice that was given by a lawyer to the post office, and I've seen that. I don't see references to it. I'm sorry. I just feel really uncomfortable trying to.
No, of course. Don't worry. I won't try and. I'll leave it alone, Mr. But I'll just.
I'm sorry. I really do want to help, but I don't feel I can here.
Don't worry, Mr. Williams. But to return to the terms of the letter that you drafted for Miss Crichton.
Yes. That
instruction from Miss Springfield was far from open, transparent and lawful, was it?
Well, I can't speak about again, I haven't had a chance to properly read it. But the skim read I've done there makes it look largely similar to a lot of precedent litigation hold communications that are sent out with some more, but I haven't had a chance to consider the detail.
Well, can I ask you that more general question then, just very quickly? Saying, right, don't put anything critical in writing because we might have to disclose it and that might cause us problems in litigation. That's the bottom line of it. Is that, reading that, is that unique in your experience or is that something which is a commonplace in civil litigation?
The warning on care and communications is commonplace in my experience of litigation. You're in litigation, be aware that if you're creating documents, they may be disclosable, and there are some protections that provide privileges to those communications.
But what about don't say anything critical in writing because that might have to be disclosed?
Sorry, thank you. That strikes me as being more focused and targeted than I've seen in typical communications like
Right, okay. I'll move on to my second topic now. And
so if we could do that, can I take a 2-minute break? Just, I think.
Provided Sir Win doesn't take the 2 minutes.
Sorry, I should have asked you, Sir Win. I'm now doing it very publicly, I'm afraid.
Sorry, I was mute. Yes, of course, you must have a comfort rate.
Thank you, sir.
Hello?
So yes, Mr. Williams has come back into the room now. Can you see and hear us?
Yes, I can. Thank you.
Thank you. Back to Mr. Maloney.
Sorry, thank you.
That's all. Second item is Crown officers, and this is a document POL 20144,855. What's the reference? It's not a complex document, this one, Mr. Williams. There's only one point to take out of it, really.
Thank you.
So you can probably look at it on the screen safely. It's the 14 bug, and it's an email from you to a number of people, Leslie Sewell, Alwyn Lyons, senior people, on the 27th of June 2013. Yep. And it refers to the 14 bug, and it says that you're writing letters essentially to all the sub-postmasters affected by it, and you say in the second paragraph, can I please have any comments on these ASAP by midday tomorrow so that they can be sent to the 10 affected branches tomorrow? And in parentheses, 10 as we are not writing to the 4 crowns also affected. Yeah. Can I just ask why, it's a short point, why were the Crown officers not having letters sent to them?
Because they're owned and managed by Post Office. It was essentially Post Office writing to Post Office.
Precisely. And but this bug, and by inference, other bugs, were also affecting Crown officers, weren't they?
I don't know to what extent they were or weren't, but the bugs would affect the Horizon system, so, which are in Crowns and others.
Yeah,
so.
Because, I mean, this says 10 as we're not writing to the 4 crowns also affected, so these bugs were affecting, whether they all were, or some of them at one time or another, etc., etc. Crown officers were being affected by these.
They could be affected by a bug equally, yes.
And the reason I ask you about this is that it may be that, and it will be, that a witness comes and says that one of the reasons I thought Horizon difficulties were not systemic, but instead must have been due to the errors and other behaviour of sub-postmasters because the difficulties didn't affect Crown officers. That would be a mistaken assumption on their part, wouldn't it?
I don't know the full context of it, but a bug would affect it. My understanding is a bug would affect Horizon Terminal.
Yeah.
I think they all had the same equipment. This is a short point.
And so far as you're aware, there's no reason to believe that bugs affected Crown officers any less or any more than sub-post officers. You just don't know, do you?
No, I don't. That's correct.
Were you aware of there being any differences of the proportion of prosecutions of postmasters as opposed to managers of Crown officers?
I'm not familiar with that.
It's not your area, is it, the criminal prosecutions? But what about civil recovery? Any difference so far as civil recovery for shortfalls in Crown officers?
Well, I don't think Post Office, it would be seeking to recover from itself at Crown.
Exactly. Whereas in the case of sub-postmasters, you could recover from sub-postmasters, couldn't you?
Yes.
And you did.
Yes.
And they had a contract which stipulated that they were liable for all shortfalls.
Depends how it's construed now. Shortfalls caused by, I think, on the pre-common issue, the old model contract, pre-common issues judgment. I think it was for errors caused by their own carelessness, negligence, or error.
Quite. But Post Office, in its approach to civil recovery, asserted that postmasters were liable for all shortfalls unless they could show they weren't responsible for them. In effect, didn't they?
Yeah, it was. I think that's slightly. All I'm able to say is I know what the contract was. I don't know how it was always enforced vis-a-vis the network, but whether it was all or just those, or what was done to determine those two. But certainly, if the point is Post Office pursue
Post office.
postmasters for shortfalls.
For
then
shortfalls,
then
they obviously
yes,
didn't
of course.
pursue Crown officers because it was their own money, but they pursued sub-postmasters because they were essentially on a contract, which meant that they were, in theory, on the face of it, liable for shortfalls, and that was the approach that Post Office took to them.
I think yes. Yes.
And they had limited resources to fight the claims against them. They couldn't afford the services of a Bond Dickinson or a Herbert Smith Freehills, could they?
Speaking very generally, I think it's safe to say they'd be less likely to. That's for sure. I would say that, yes.
Now, just finally then, the remote access and Project Zebra.
Yes.
And I'd like to take you to POL 202554949.
Oh, beg your pardon. Sorry, Ms. Malone, can I put the
Sorry,
reference?
I'll find you the reference in the...
Thank you.
Whilst I'm getting you the reference in the in your B275, Mr. Williams, and I'm grateful to Ms. Patrick.
Thank you. I can see it as well.
Yeah. Now, this is an email from Amy Prime to you on the 26th of July 2018.
Yes.
And we can see it's copied in Andrew Parsons, Mark Underwood. And this is a query about privilege. And for reasons of time, have you looked at this document before you came to give evidence and you remember it?
Yeah, I did. Thank you. Yes.
Essentially, it's Amy Prime asking about privilege in relation to documents which relate to Project Zebra. That's the Deloitte report. And most documents covered by privilege, but they've come up with one. They've found one. And this is the Zebra Action Summary. I've attached the email chain, but the document of interest is the Zebra Action Summary attached to the email. This is a document produced in response to the Zebra report, which sets out the recommendations from the report and the remediation which should be implemented to Horizon. Council's initial view is that privilege cannot be claimed over the whole of the Zebra Action Summary, but the parts which repeat or summarise the contents of the Deloitte report can be redacted. And then she asks you to ask a few questions of people. Do you remember this?
I didn't remember it specifically, but I have seen this as part of the preparation for it. So
Yeah.
yes.
So it's plain that, if possible, they would like to keep privileged and not disclose the contents of the Deloitte report as summarised within the document.
The way I read this is that they're considering privilege over the extracts of the document.
Absolutely.
Yes, absolutely.
Consistent with the approach to Deloitte more generally.
Yep.
You've said that the Post Office didn't understand the full significance of the Deloitte report until the chairman's report. Is that right?
No, I wouldn't have said that. What I said is that the full significance of the remote access piece.
Yeah.
So that particularly G. That is
lack of precision on my part.
No.
Essentially, did it boil down to that you didn't appreciate they could delete in an undetectable way?
Because I think it referred to the balancing transactions piece. It was the audit store. The piece I hadn't appreciated was the ability to access the audit store, remove and replace.
That's it. So to delete material and then replace it in
replace.
an undetectable way.
That was the bit I recall giving evidence about. I'm sorry if it's...
Exactly. That you hadn't appreciated the full significance, and so far as you're aware, other people in Post Office hadn't appreciated that significance from the Deloitte report either.
Yes.
Yeah.
Yes.
And until the chairman's report.
That's what my recollection is, yes.
Now, in order to comply with these requests, did you examine the Zebra Action Summary? I won't waste time. I'll just take you to it.
I don't recall doing that. Was it attached to the email?
Yeah.
Yeah.
And that it says it's attached.
Okay. Thank you. Then I may well have done, and I certainly...
Can we have a look at it, please? POL 30s 31409. POL 30s 31409. And E25, please, Mr. Williams.
Oh, E25.
Yeah.
Open, sorry. Thank you, I'm so sorry. Yes.
So, yep. Page 6, if we could, just to identify it, 12th of June, 2014, version 3, authors James Rees, Emma McGinn, Julie George. And these are the people who are referred to in the email that you're asked to ask questions about. Page 6 of this, please, 4.2.2. Now, this is a document produced within Post Office by technical people within Post Office, and it says at 4.2.2, data logging.
Yes.
One point raised in the report, and that's referring to the Deloitte report, was that it was possible for someone with privileged access to delete data from specific areas of Horizon. This is always a risk with individuals using admin or power user accounts, and it's a persistent risk, one that needs to be catered for in almost any organisation. Due to the sensitive nature of the information contained in the databases, monitoring of those databases should be put in place using technology to detect and record deletions and administrative changes to the databases. If possible, alerts should also be generated for mass deletions and high-level risk changes to database schemes. So this is an internal Post Office document. It's from June 2014.
Yes.
It says that the Deloitte report identifies deletion, the potential for deletions, and that processes need to be put in place in order to ensure that that doesn't happen in an undetected way. So it's plain that these people in Post Office understood that data could be deleted.
They're certainly discussing it in this, yes.
Absolutely. Now, can I now take you to an email which is POL 00346 E129 for you, Mr. Williams, and I'll repeat the 00346 958 for the document handler.
E129, is that right?
Yeah, that's it. Remember at the time, you, Mr. Williams, were involved in certifying in May of 2014 2 second site formal certifications. It was described by Mr. Andrew Parsons that there couldn't be access to delete. That was what second site required, and you explained how things happened. This is in June of 2014, and this is an email from Julie George, who is the person producing the report, and it's to Rod Ismay, David Mason, and Malcolm Zack. So you're not copied into this. But what it says is, hello all, I've tried to call you, Rod, attached a draft summary of actions arising from Deloitte's recent piece of work on the Horizon system. So that's the Zebra Action Summary we've just looked at, and we can see it in the subject, Zebra Action Summary version 3, and the attachment, Zebra Action Summary version 3. Clearly there's no blame attached anywhere, and this morning's meeting with Chris Day, Chris Ojard, Leslie, that'll be Leslie Sewell, and Malcolm, focused on what we would need to put in place as an organisation to address overall assurance on all critical systems, starting with Horizon from the 1st of April. So it looks like that morning, the 17th of June 2014, General Counsel, Interim General Counsel as he was, Mr. Ojard, had been at a meeting with, amongst others, Leslie Sewell, the head of IT, where Zebra Action Summary had been discussed. Did anybody ever raise with you the contents of the Zebra Action Summary at this time when you were providing second sight with, as it were, formal certification that there could not be remote access to delete and replace entries in the audit?
I don't recall. I do recall that at some point, I think there is a document where I explained that something arising out of these works involves balancing transactions, which I was interested in, but I don't recall this.
You don't recall delete in an undetectable way, because those are the things that you ultimately were very surprised about when Jonathan Swift, Queen's Counsel, as he then was, drew your attention to that in the report.
Yes, that's my recollection, yes.
Thank you very much, Mr. Williams. That's all I ask.
Thank you.
Thank you, Mr. Maloney. So first of all, Mr. Williams, I believe that is the end of the questioning for you. So I am grateful to you for your detailed witness statement and for you giving evidence over the past 2 days. So thank you. I'd like to thank the counsel, leading counsel, and Mr. Jacobs for the discipline which they've showed in keeping to time limits. I understand, Mr. Beer, we plan to start again at 9:45 on Tuesday, is that correct?
Yes, that's right, sir.
So we'll begin again at 9:45 on Tuesday with Ms. Crichton, yeah?
That's right.
And so we'll adjourn until then. Thank you very much.
Thank you, sir.